Hello and good afternoon. My name is May and I'm the principal lawyer and founder of ME Law. And for 10 plus years, we've been helping businesses like yours handle breach of contract claims and disputes. We are strictly a litigation-focused law firm and can really handle all kinds of business matters. So grab your drink and let's jump into understanding contract breaches. Welcome to our breach of contract, how to defend your business interests. In this webinar, we will guide you through the essential strategies of effectively defend your business against breach of contract claims. As business owners, entrepreneurs, and corporate leaders, it is crucial to understand the legal landscape and have the tools at your disposal to protect your interests in the face of disputes. Contracts serve as the very foundation of every business relationship, and while breaches are common challenges, knowing how to manage and address them is key to protecting your business's future. This webinar is designed to provide you with a solid understanding of what constitutes a breach of contract, proven defensive strategies to protect your business, insights into minimizing the risk of future breaches and disputes. By the end of the session, you'll be well equipped to confidently navigate breach of contract scenarios and take proactive steps to defend your business. I would like to also note here that every situation is fact specific, but these contract breaches are generally what individuals face. This foundational knowledge is crucial for identifying potential risks and setting up a strong defense strategy. So let's dive in. A breach of contract occurs when one party fails to fulfill their obligations as agreed in the contract. This can lead to significant legal and financial consequences for both parties involved. In this section, we will break down the different types of common breaches, their legal implications, and provide insights into the legal landscape in both Ontario and British Columbia. A breach of contract happens when one party fails to perform or uphold their obligations under the terms of the contract. This really may occur due to non-performance, delay, or failing to meet specific terms outlined in the contract. When a breach occurs, it can have serious implications, including potential legal actions for damages or contract termination. The types of breaches that you are most likely going to encounter. A material breach is a substantial failure to perform one of the most important provisions of the contract. This breach impacts the core purpose of the agreement. In Ontario, a material breach typically allows a non-breaching party to terminate the contract and seek full damages. A material breach must be significant enough that it goes to the very foundation of the agreement, such as a supplier failing to provide a product that the business cannot operate without. A minor breach, on the other hand, does not undermine the entire agreement, but might still result in damages for the non-breaching party. For instance, if a delivery arrives late but does not affect the overall business operations, this will be considered a minor breach. In Ontario and British Columbia, minor breaches do not typically justify terminating the contract unless the breach is substantial enough to affect the agreement's purpose. This type of an actual breach occurs when one party fails to meet their obligations when they are due. This is the most common form of breach. In Ontario and British Columbia, an actual breach may allow the non-breaching party to either terminate the contract or seek compensation depending on the severity of the breach and the specific terms of the contract. Now, both in Ontario and British Columbia, there are various defenses against breach of contract claims. These defenses can significantly impact the outcome of a breach of contract case. So it's important that you know these defenses. A contract can be considered frustrated under Ontario's Frustrated Contracts Act. If an unforeseen event makes it impossible for a party to perform their obligations, for example, if a contract requires a party to provide a service that cannot be performed due to government restrictions or natural disaster, the contract may be deemed frustrated. In Ontario, frustration discharged both parties from their obligations. Similar principles under British Columbia's contract law apply. If an unforeseen event, such as a fire or government action, renders performance of a contract impossible, the courts in BC may apply the doctrine of frustration, excusing non-performance and potentially relieving both parties from further obligations. Force majeure is another big thing. Many contracts include a force majeure clause, which excuses performance under certain conditions beyond a party's control, such as natural disasters or even emergencies. In Ontario, the force majeure clause is enforceable when the event described in the contract actually occurs and prevents performance. We have seen lately that the force majeure clauses are becoming more clarified and more information is added in those clauses. BC law similarly enforces force majeure clauses, but may require a clear specification in the contract about what events qualify as force majeure and the procedures for notifying the other party. The recent COVID-19 pandemic brought attention to the use of these clauses in both Ontario and British Columbia, where government-imposed restrictions were looked at by the court. Some decisions deemed force majeure events in some commercial contracts. In other contracts, it wasn't deemed enforceable. Both Ontario and British Columbia recognize the doctrine of impossibility under certain circumstances, and fulfilling the contract becomes impossible due to unforeseen events or changes in law. A party may be excused from performance. For instance, if a supplier cannot deliver goods because they have been destroyed, performance may be considered impossible and the contract may be discharged. A contract may also be void or voidable if one of the parties did not have the legal capacity to enter into the agreement. This could occur due to factors like fraud, misrepresentation, or coercion. In Ontario, contracts can be voided if they were made under duress or if the contract terms are unlawful. Similarly, British Columbia's Business Corporations Act provides remedies for contracts made by individuals who do not have the authority to bind a corporation. In Ontario, there is an applied duty of parties to act in good faith when performing their contractual obligations. A failure to act honestly or a failure to fulfill the duty of good faith may be a valid defense against breach of contract claims. This is similarly recognized in British Columbia, where courts must consider whether a breach was the result of bad faith or fraudulent behavior. Now, once a breach has occurred, both Ontario and British Columbia provide several potential remedies for the non-breaching party. The most common remedy for a breach of contract is compensatory damages. The goal is to place the non-breaching party in the position they would have been had the contract been performed. Both Ontario and British Columbia use compensatory damages to cover actual losses suffered by the non-breaching party. Then you have consequential damages. These damages are awarded for losses that are indirect but result from the breach. In Ontario, if the non-breaching party can prove that they suffered a loss due to the breach, such as lost profits, they may be entitled to consequential damages. British Columbia courts similarly recognize consequential damages in breaches of contract claims. In some cases, a court may order the breaching party to perform the contract as agreed through specific performance. This remedy is often used when damages are not an adequate remedy, such as in cases involving unique property or services or goods. Both Ontario and British Columbia courts have applied this remedy where appropriate, but the court would typically consider whether it is feasible to enforce specific performance. If the breach is deemed material, the non-breaching party may have the right to terminate the contract. Both Ontario and British Columbia law provide for the termination of contracts in cases where a material breach deprives the non-breaching party of the benefits of the contract. Now that we explored these types of breaches and legal defenses available in Ontario and British Columbia, let's move to assessing your legal position in the event of a breach. Understanding how to evaluate whether a breach has occurred and the impact it may have on your business is key to determining your next steps. let's dive into the factors you need to consider when assessing your legal position. After identifying a breach of contract, the next crucial step is assessing your legal position, evaluating the breach's impact on your business, and understanding the legal implications will help guide your next steps and determine whether to take legal action. This section will cover how to assess the breach, review the contract, evaluate the consequences, and decide on the best course of action to take. Once you recognize the breach has occurred, it is essential to assess how it affects your business operations. Start by determining the level of disruption caused by the breach. How crucial is the breached obligation to your ongoing operations? For example, if a supplier fails to deliver goods on time, causing production delays, this may lead to operational setbacks and financial losses. In contrast, a minor delay might only affect internal schedules without disrupting client deliverables. You need to evaluate the financial damage caused by the breach. Has the breach caused direct financial losses, such as paying for undeliverable goods, or are there actual costs associated with fixing the breach, like hiring an alternative supplier? Calculating the full costs will help you determine whether pursuing legal remedies is worth the effort or if negotiation would be a more practical solution. You also need to consider the impact on your business relationships and your reputation. Will this breach harm your relationship with clients, partners, or suppliers? A breach could lead to reputational damage that affects long-term trust. If the breach is material and causes significant damage to your brand, you may need to consider a more aggressive legal response. Now you need to review the contract. Now you need to review the specific provisions of the contract to understand the terms that apply in the case of a breach. This is crucial in assessing your legal position and understanding what actions to take. Contracts often contain provisions that define the breach and the available remedies. These clauses may specify if you have the right to terminate the contract, seek damages, or request specific performance. By reviewing these sections, you can understand your options and avoid missing any required steps, such as providing notice to the other party. Many contracts require a non-breaching party to notify the other party of the breach and allow them a certain period, called a cure period, to fix the breach before taking further action. In Ontario and British Columbia, proper notice and a cure period may be required before you can seek remedies such as termination of the contract or damages. You also need to understand that you can negotiate every contract you enter into and add these specific terms to them if they are not in the contract. Again, you can also, you must look to see if there's a force majeure clause that excuses your performance due to unforeseen events such as natural disasters and so forth. You need to look to make sure you understand the jurisdiction specified in the contract, that as it dictates which province's laws or state laws will apply in the event of a dispute. For example, if the contract is governed by Ontario law, the Ontario law applies, whereas for a contract governed by British Columbia, the law of British Columbia will likely be relevant. Once you understand the breach and its impact, it is important to consider any potential defenses the breaching party may raise. Knowing these defenses will help you assess how to proceed and whether you may encounter any challenges in taking legal action. As explained, Ontario law, we have the Frustrated Contracts Act, okay, and British Columbia law, frustration can basically discharge a contract if performance becomes impossible due to unforeseen events. It's really fact specific. This is typically used in extreme cases as natural disaster or sudden law change that makes the contract impossible to perform. Again, you want to turn your mind to force majeure. If the breach was caused by an external uncontrollable event, the breaching party may invoke the force majeure clause. This would excuse their non-performance. You also need to consider both good faith and fair dealing. Both Ontario and British Columbia impose an implied duty of good faith in contracts. If the breaching party failed to perform in good faith, for example, intentionally delaying or deceiving, they may not be able to use defenses such as frustration or force majeure. Fair dealing implies that parties must act honestly, reasonably, and fairly. Their actions cannot undermine the minor party's ability to recoup the benefits of the agreement. Then you need to consider capacity and consent. In some cases, a contract can be voided if one party lacked the legal capacity to enter into, such as a minor, someone who is facing mental health challenges, or someone who entered a contract under duress. These offenses could be raised in both Ontario and British Columbia, depending on your circumstances. After reviewing the breach, its impact, and the legal defenses, it's time to decide how to proceed. Based on your evaluation, you may have several options. In many cases, a breach can be resolved through negotiation. This is essentially effective for minor breaches or where a quick resolution is desirable. Negotiation might involve renegotiating terms, agreeing to a settlement, or extending deadlines. If the breach does not significantly undermine the business relationship, this could be a practical approach. If the breach has caused significant financial harm, you may want to pursue damages to compensate for your losses. Both Ontario and British Columbia allow for compensatory and consequential damages in the case of a breach. You may also seek punitive damages if the breach involved malicious or fraudulent actions. If the breach is material and has undermined the core purpose of the contract, you may have the right to terminate it. This is essentially relevant if the contract explicitly allows termination in cases of material breach. Be sure to follow the contract's procedures for termination to avoid potential disputes. If monetary compensation, as I mentioned, is insufficient and the contract involves unique goods or services, you may pursue specific performance. Okay, this remedy compels the breaching party to fulfill their obligations as agreed. However, it's only available in certain circumstances. After assessing your position and considering the available remedies, it's crucial that you reach out to our office and book a consultation with myself or any of our lawyers. We are experienced lawyers who deal with these issues on a daily basis, and we will help you understand your rights and options, ensure you comply with the required legal procedures, and represent your interests in negotiation or arbitration or through the courts. As legal experts in both Ontario and British Columbia, we can guide you through the complexities of the respective jurisdictions' contract laws and help ensure that you take the appropriate actions in response to the breach. Now that you have assessed your legal position and explored options, let's move on to the next phase, how to take actions effectively. We will explore steps involved in filing a breach of contract claim, including the procedural aspects and considerations that may arise as you move forward. Once you've assessed your legal position and decide on the appropriate cause of action, the next step is to file a breach of contract claim or to proceed with the steps that are outlined in the contract that can be taken, either through negotiation, as I mentioned, arbitration, or a formal court proceeding. It's essential that when you do enter a contract, there is a clause related to if a dispute is to arise in relation to this contract, this is the way the parties are agreeing to proceed, i.e. arbitration or mediation. Binding arbitration or mediation. In this section, we'll discuss the steps involved in filing a claim, the key requirements in Ontario and British Columbia, and how to prepare your case to ensure a smooth process. The first step in filing a breach of contract claim is to determine the appropriate court or forum where the case should be filed. Both Ontario and British Columbia have well-defined procedures for handling contract disputes, but the process will depend on the nature of your case. It's important to note that in both Ontario and British Columbia, there are time limits for filing a breach of contract claim. In Ontario, the statute of limitation is generally 2 years from the date the breach occurred, while in British Columbia, it is also typically 2 years from the time the breach is discovered or reasonably should have been discovered. So you need to be aware of that. It's a 2-year limitation period. In Ontario, breach of contract cases are generally filed in the Ontario Superior Court of Justice, unless the amount in dispute is under $35,000, in which case you can file it in the small claims court. For claims involving higher amounts or where the legal issues are more complex, the Superior Court might be the jurisdiction to handle the case. In British Columbia, breach of contract claims are filed in the Supreme Court of British Columbia for cases involving more than $35,000. For cases involving smaller amounts, the Provincial Court Small Claims Division handles the case. It is important to review your contract and jurisdictional terms to confirm where the case should be filed and whether the contract specifies any alternative dispute resolution process, such as mediation and arbitration. Once you've determined the appropriate court or forum, the next step is to prepare and file the necessary legal documents. The most common document you file if you're proceeding by court is a statement of claim, or the plaintiff's claim as it's called in BC. The document outlines the details of the breach or any other causes of action you're taking, damages you're seeking, and your legal basis for the claim. What to include in a statement of claim. Clearly identify the parties involved in the contract and the breach, including their legal names and addresses. Explain the facts surrounding the breach, including the type of breach, material, minor, anticipatory, etc. The specified provisions of the contract that were violated and any relevant dates, example, performance dates, breach notice dates. Specify the remedy you are seeking, whether it is compensatory damages, specific performance, or contract termination. Be clear about the financial losses or other damage incurred due to the breach. Once you do all that, in Ontario, the statement of claim is filed and issued with the court, and must then be served on the defendant or the defendants. Service can be done in person, though an alternative method can be available if you can't serve in person, and that is approved by the court, and the court relies on the rules of civil procedure to do that, the Ontario rules. In BC, after filing, the plaintiff must serve the defendant with the statement of claim, and this must be done, again, according to the BC Supreme Court civil rules. So they have their own rules of filing. Once a statement of claim has been filed and served, the defendant has set periods to respond, typically 20 days in Ontario and 21 days in British Columbia, if the defendant is being served in the province. If the defendant is being served outside of the province in another country, they have different time frames. That it will be on the cover sheet of the issued and filed statement of claim or plaintiff's claim, and the defendant will follow the necessary instructions on that document they receive. The defendant may file a statement of defense in which they will outline their position and any defenses they are raising. Before they file a statement of defense, the defendant can file a notice of intent to defend. We've already talked about some of these, but in response to a defense, a defendant can basically argue frustration of contract. They can say that the performance was impossible due to unforeseen circumstances. They can argue force majeure, and they can give a good faith defense argument. That they argued in good faith and that the breach was non-intentional or was due to a minor issue that does not warrant severe remedies. It is essential that once the plaintiff gets the statement of defense, that you carefully review it, you understand the arguments raised, and you assess your position. Depending on the defense, you may need to respond with a reply, or you may need to respond with particulars, or you may even get someone asking to review documents. It's important that you come to our office and get advice on how to respond. Once all of this done, discovery, or it's called discovery in Ontario, it's called disposition in the British Columbia, but it's a process that forms part of the steps to the proceeding. It involves exchanging information and evidence between the parties to build the case. A plaintiff can seek a summary judgment motion as well to get a hearing without having to have a full trial. In Ontario and British Columbia, discovery is an essential part of the litigation process, and both parties are required to disclose key evidence that will support their claims. Types of evidence that you should be having, you should keep on the side and you should be able to disclose is contractual documents, copies of the contract itself, any amendments or related correspondence. You should have disclose and keep communication records like emails, letters, or other written communications between the parties that demonstrate the breach or related discussions. You should have invoices, receipts, or other documents that show the financial impact of the breach, such as lost profits, extra costs incurred, or expenses related to the breach. Then what will happen once that is exchanged through an affidavit of documents, discoveries will take place where both parties will be examined on their pleadings, and they will be examined on their materials they produce. And at that point, lawyers will tend to want to get admissions or seek additional documents. Now, I just want to briefly, before I go into what happens in trial, before proceeding to trial, okay, lawyers, if you have a good lawyer like from our firm, we would encourage parties to try to take alternative dispute resolution, such as mediation. If you don't have arbitration in your contract, we try to encourage the parties to get consent to seek to have arbitration as the method of choice to deal with this issue. The only reason is because it's very private. It keeps issues out of court. It is it's a quicker process, and it can be less costly and time consuming than going to trial. Okay. Now, in mediation, if you were to do mediation, a neutral third party will come in and help the parties discuss the issues and reach a mutually acceptable settlement. It's often voluntary. There are some contracts that require it before going to court. The same thing with arbitration, as I mentioned. It is like a mini trial. It involves a neutral third party. The third party will get statements, will have a notice of, someone will file a notice of arbitration. They will, the third party will hear both sides. There'll be cross-examination. There'll be either written arguments, or you give submissions, and they render a decision which may or may not be binding. If you're trying to seek arbitration on consent, it's usually you should get it that it should be binding, and it's more formal than mediation, but still less expensive than full court. If you go to court, if you negotiate, i.e., you just try to negotiate with each other, and that negotiation fails, and you try different ways of doing this, okay? You try different ways of settling it, and the settlement is not successful, the case will proceed to trial, okay? At trial, both parties will present their arguments, evidence, and witnesses. The judge will then render a decision. If, typically at ME law, what we do, if it's a really narrow issue that maybe we just need the substance of the issues have been decided, have been agreed to, have been settled, but there's a narrow issue that we might need a judge to provide input on, we take the necessary steps to get a judge involved before we actually have to go to full trial. Trials in Ontario at the Superior Court of Justice typically involve a judge and sometimes a jury. For certain cases, the judge will review the evidence, apply the relevant law, and issue a judgment on whether a breach occurred and what remedies are appropriate. Then after that, what usually happens is then you do cost submissions if the court doesn't want to hear it at the same time. British Columbia trials are heard in the Supreme Court of British Columbia. They follow a similar process with the judge, considering the evidence and issues. A decision is based on contract law and applicable legal principles. The judge may order remedies, such as compensatory damages, specific performance, or contract termination, depending on the nature of the breach and the relief sought. Now that we covered the steps in filing a breach of contract claim, let's move on to defending your business interests when facing a breach of contract. We will discuss strategies for minimizing the impact of the breach, protecting your rights, and negotiating favorable outcomes. When faced with a breach of contract, your first instinct may be to focus on the immediate legal action required to protect your business. However, it's equally important to consider proactive steps that can help defend your business interests and minimize the damage. In this section, we'll discuss strategies to protect your business, managing the situation, and ensuring that you're in the best position to move forward. First, you want to maintain business continuity and good faith. Even if the breach is on the other side, continue fulfilling your responsibilities wherever possible. This shows that you're committed to good faith performance, which is essential for protecting your reputation and preventing accusations of double breach. Why good faith matters? It signals your commitment to the contract and can help avoid negative repercussions in litigation or negotiation. Action plan, document all your actions, communications, compliance steps, and efforts to fulfill your obligations, especially in the face of challenges. For example, if a supplier fails to deliver essential materials, but you still need to deliver goods to your clients, work on alternative solutions like finding a new supplier or delivering what you can. Second step is you need to have proactive communication. Open, clear communication can help avoid escalating the breach into a legal battle. This is essentially true when there are misunderstandings or temporary setbacks. Uncover the underlying issues and find mutual solutions before heading straight to litigation. Action plan here, initiate professional, non-confrontational discussions with the breaching party to understand their side and propose possible solutions, such as extensions, renegotiations, or adjustments to the terms. For example, if a vendor doesn't meet agreed quality standards, propose a compromise such as discount or extended deadlines to fulfill the agreement. Next, you want to assess your legal remedies, know your options, understanding your legal rights and potential remedies for breach of contract help guide your decision. Options may include claiming damages, seeking specific performance, or terminating the contract if necessary. This is crucial because knowing your remedies helps you make informed decisions on how to proceed based on the severity of the breach. Action plan here is review the contract to identify clauses that specify remedies or steps to resolve a breach, calculate potential losses to understand the magnitude of the breach, and justify your remedy claim. For example, if a supplier fails to meet deadlines, if a supplier's failure to meet deadline causes significant losses, you may seek compensatory damages, or if severe, terminate the contract entirely. Now, to protect against future breaches, consider using insurance or strengthening your contracts to mitigate risk. Businesses can utilize performance insurance or other coverage to manage the financial impact of breaches. Why insurance help? It provides financial protection, reduces the strain on your business in the event of a contractual failure. Action plan here, review your insurance policies to ensure they cover risks related to breaches of contract. Consider adding clauses like force majeure or business interruption to safeguard future agreements. For example, if a supplier fails to meet their contractual obligations, performance insurance could cover the cost of finding a replacement supplier, thus mitigating the financial blow. Now that we discussed strategies for defending your business interests during the breach, let's move on how to minimize future risks and protect your business from breaches in the future. We will explore best practices for building stronger contracts, enhancing communication, and safeguarding your business against future legal issues. After dealing with a breach of contract, it's essential to take steps to prevent future breaches and strengthening your business operations by putting in place preventive measures. You can reduce the likelihood of contractual disputes and protect your business interests over the long term. In this section, we'll discuss best practices for safeguarding your business against future breaches and ensuring that your contracts are solid and enforceable. One of the most effective ways to prevent breaches is to ensure that your contracts are clearly defined, comprehensive, and legally enforceable. Contracts should outline the expectations, duties, timelines, and consequences for non-performance. Avoid vague language. Make sure all terms are clear and specific. You can have a definition sheet included. You should include performance deadlines, quality standards, payment schedule, and dispute resolution procedures. In Ontario and British Columbia, contracts with ambiguous terms may be harder to enforce, leading to potential misunderstanding and breaches. Key contract elements to include performance standards, as clearly outline the expectations for how work should be performed, including deadlines and deliverables. Specify what will happen in case of a breach. such as penalties, damages, or termination clauses. Ensure the contract has a force majeure clause, and specify the method for resolving disputes, whether through negotiation, mediation, or arbitration, before resorting to litigation. Always have a lawyer from ME Law review your contracts before finalizing them. Legal professionals can ensure your contracts are legally sound, that your interests are protected, and that they comply with the relevant provincial laws in Ontario or British Columbia. You should develop, preventing breaches doesn't only depend on the contracts themselves, but also on the relationship you maintain with your suppliers, clients, and partners. Conduct thorough due diligence before entering into contracts, whether you're working with vendors, clients, or business partners. Ensure that they have a history of fulfilling obligations and are financially stable. In Ontario and British Columbia, it's important to verify the reliability and reputation of the parties you're entering into an agreement with. Regular communication with vendors, suppliers, and clients helps ensure that everyone is aligned on expectations. If issues arise, addressing them early on can prevent them from turning into breaches. Establishing, as I mentioned, clear communication channels. Maintain clear and open lines of communication to facilitate problem solving and collaboration. Frequent check-ins and progress updates can help avoid misunderstandings. If the relationship is long-term, review clauses that allow you to assess performance regularly. This helps you address any issues before they lead to a breach, especially in ongoing service contracts. Now, risk management is also crucial in identifying potential breaches and mitigating them before they escalate. Okay? Proactive risk management involves assessing potential issues, monitoring contracts, and taking corrective actions when necessary. You should do regular reviewing of your existing contracts to ensure that compliance and monitor for any performance issues. In Ontario and British Columbia, this can really help you identify potential breaches earlier on and prevent larger legal problems down the road. You should identify areas where breaches are most likely to occur. For example, if late deliverables from a supplier are common, put measures in place to address the issue before it becomes a breach of contract. You should regularly assess risks related to supply chain issues, employee performance, and external factors like economic conditions or regulatory changes. You should establish internal monitoring systems to track contract milestones, deadlines, and obligations. Automating reminders for key contract dates such as delivery schedules and payment due dates can minimize the risk of an inadvertent breaches. Okay, and I'm just going to briefly go through this slide. Basically, you can use technology to monitor and manage your contracts, right? There's contract management software. There's benefits to that. For example, automating reminders for key dates and so forth. So if you're a big company that has a lot of contracts, or you're in a place of putting in a lot of contracts, it's important to think about how you can make it easier for your business. You should also have digital signatures in e-contracts. This way they become legally binding, and there's a track of the signature. These tools really streamline the contract process, making it easier to sign and execute agreements, which at the end will reduce the likelihood of any errors or omissions that could lead to a breach. You should also educate and train your team. I think the key thing here is, in order to prevent breaches, it requires your employees and partners to understand the importance of a contract compliance and potential consequence of non-performance, right? You should provide training for your team, right? Adhering to contractual obligations, educating employees on the terms of key contracts and the consequences of breaches, okay? This really ensures that your organization's on the same page, and one hand is performing because the other hand is performing, right? So you have that even level playing field, and there's a smooth operation to your business. You should develop internal policies, right? relate to contract management and breach prevention. These really can include procedures for handling disputes, reporting issues, and managing deadlines. It's very much important to have that in place. It will prevent breaches from occurring due to internal miscommunication or errors. Okay, so in order to make sure that you're not doing the breach because of a miscommunication and losing thousands and millions of dollars, it's really much important to have these lines of communication open. Then you want to monitor the changes in laws or regulations which can affect the way contracts are executed or enforced. Staying informed about updates in contract law, updates in changes in government policy in both Ontario and British Columbia is really essential for preventing breaches. You need to monitor changes to provincial contract law as well, regulatory changes that can impact your business contracts. Legal landscape is always evolving, right? So you need to stay informed. The case law is very much always evolving too, to ensure that you can avoid all this unintentional breaches. Regularly consult with a legal advisor from ME Law. We are always available to ensure that your contracts comply with the latest legal requirements, and we can help you a great deal in avoiding any pitfalls and minimizing your risk for future legal disputes. Subscribe to our LinkedIn channel at ME Law Toronto. We often provide a lot of information on a daily basis in terms of the changes of law and what you need to do. So we offer a lot of material for you to be educated on the changes of law. Now, you want to build a culture in your business of compliance, right? Within your organization, which really reduces the risk of breaches, right? When employees, partners, and suppliers understand the importance of fulfilling contractual obligations, your business is better positioned to avoid future disputes. And if a dispute arises, your business is in a better position to either be on the plaintiff side or on the defendant side, right? So you want to make sure that you have all these in place to show that you're actually coming to court with clean hands. Make it clear that your business prioritizes contract compliance when everyone in your organization is committed, and everyone in the organization is committed to honoring agreements. Breaches are less likely to occur. Conduct internal audits to ensure compliance with contracts and identify areas where improvements can be made. Regularly do checks and so forth. Now, I want to look to you, turn a little bit on things that are issues now that is currently pressing to really our community and our country, right? Trade between the U.S. and Canada is a significant aspect of many businesses, especially those involved in cross-border commerce. However, changes in tariffs and trade policies can really have a direct impact on contract performance and business interests. Okay, in this section, we will explore how U.S.-Canada trades tariffs affect contract obligations and what you can do to manage these challenges. Tariffs are taxes imposed by governments on imported goods. They are a significant factor in international trade, particularly between countries like the U.S. and Canada, and U.S. and Canada and Mexico, where trade flows are large and interconnected. Changes in tariff rates can affect the cost of goods and services, really potentially leading to a breach of contract if the obligations can no longer be met at the agreed upon price or timeline. If the government imposes a new tariff or increases an existing one, the cost of importing goods rises. If a contract is based on fixed prices, this increase can render the original agreement financially unfeasible for one of the parties. For example, a Canadian company imports goods from the U.S. at a fixed price. If the U.S. government imposes new tariffs, the cost of goods increases, making it difficult for the Canadian business to honor the original price, leading to potential breach of contract claims. Changes in tariffs can also affect supply chains, causing delays or increased costs. These delays can result in missed deadlines, which may constitute a breach of contract. For example, if a Canadian manufacturer relies on a U.S. imported raw materials to produce goods, The imposition of new tariffs could delay shipments, disrupting production and leading to delays in fulfilling customer orders. Now, how do you manage the risk of tariff changes in contracts? To mitigate the risk posed by fluctuating tariffs, it is really important to include specific clauses in your contracts that address potential changes in trade regulations. These clauses can protect both parties in case of unforeseen tariff increase or changes. Price adjustment clauses are important too for dealing with tariff changes. These clauses allow for price adjustments in the event of a significant changes in costs due to tariffs or other factors. By including such clauses, you ensure that the contract remains viable even if the tariff increases unexpectedly. For example, a contract might include a clause that allows the price to increase if tariffs are imposed after the agreement is signed, ensuring both parties share the burden of additional costs. Again, the force majeure clause. I know you're probably all tired of hearing that. It's a very important clause, and it can really excuse performance if an unforeseen event such as the imposition of tariffs or changes in trade law makes fulfilling the contract impossible. This clause typically covers extraordinary events beyond the control of both parties. For example, if new tariffs create an unexpected barrier to delivering goods, a force majeure clause could excuse the supplier from meeting the delivery deadline, provided the event qualifies under the terms outlined in the clause. You can have renegotiation clauses, including a renegotiation clause. Allows both parties to revisit the terms of the contract if circumstances such as tariff changes significantly alter the terms of the agreement. This provides an opportunity to adjust the contract in response to external economic conditions. For example, a company might include a clause that allows renegotiation of terms if tariffs increase by a certain percentage, ensuring both sides can agree on a new workable solution. Despite best efforts, tariff changes may still lead to disputes. If such a dispute arises, it's essential to have a clear process for resolving the issue. You should have dispute resolution clauses in your contracts. They should include clear dispute resolution procedures, as explained before. This prevents really lengthy and costly litigation, especially in international contracts where parties may be located in different jurisdictions. For example, if a U.S. manufacturer's failure to meet the agreed delivery terms results from new Canadian tariffs, mediation or arbitration can offer a solution without resorting to formal court proceedings. You also want to document tariff-related disruptions. In an event of a dispute, it's essential to document how tariff changes. Okay? And thank you so much for... document the disruptions. Also look at the legal considerations of Ontario. Okay? Sorry. Thank you. Thank you everyone for attending today. I really appreciate it. You can follow us. I'm going to get into some questions. I have a question and answer period, but you can definitely follow us on social media. We have a LinkedIn page at ME Law Toronto. We have a Twitter, ME Law Toronto. We have a YouTube, ME Law Litigation Services. We have Facebook, ME Law Toronto, and we have ME Law Toronto Instagram page. And I think I'm going to look at my first question here. From Carlos here. I and my former partner agreed to mediation, but we can't reach solution. We should go to court. Carlos, I would have to, you should come into my office, book a consultation with me. I want to go and see what's happened. What is the main reason that mediation failed, and what is the main issue you have outstanding, and I can advise you on that. But you might have to go to court, so it's better if we set up a consult and we can have that discussion. Elena, can a breach of contracts case be resolved without going to court? Yes, as I explained, it can be resolved without going to court. You can resolve it by way of doing a mediation, like Carlos had mentioned. You could do arbitration, which is a private court proceeding, and so forth. Thank you, Jake, for that comment. I really appreciate it. I think it's saying verbal or email agreements qualify as a contract. So this is a very, very good question. First of all, I would have to look at verbal agreements. In some cases, the courts have indicated that if someone's relied on a verbal agreement and they've actually taken steps based on that verbal agreement, that could be seen as a contract. So there is case law out there that states that. So it's really case and fact specific. So it's very much important for us to really understand, like, what was the verbal agreement, what actions were taken in reliance to that, because there's case law out there that indicates that those are agreements. Those can be seen as a contract and you entering into agreement. I think let me see if there's any more. Give me one sec. Thank you, everybody, for coming. If you have, feel free to reach out to us with any legal issues you have. If you want us to look over some contracts, we're very well versed in this area of law, and we're pretty good at what we do. We get good results for our clients, and we're very creative. So reach out to us. We look forward to seeing you on our next webinar. Thank you very much.